Hi, everybody. I'm Ushangi Bakhtadze, and I'm going to talk about whether criminalization of disinformation is a good idea or not. For several years already, I am really interested in the issues of criminalization in this country. And my dissertation is actually about the issue of criminalization, and it is first of its kind that has been written in Georgia. I mean, that's empirical work that summarizes what steps state shall follow when it wants to criminalize particular action or not. And I created a model of criminalization, actually. And based on this model, I want to have this information, whether it falls under my model and can we criminalize, or it is a good idea to criminalize it or not. So basically, my talk is about that. So as a starting point, we shall say that daily rates of internet use in Georgia and news consumption slowly, but steadily shifting to the online space. Questions have been sparked rightly about how to address problems related with disinformation. The problem is even more evident if you think about the fact that sometimes disinformation is root cause of the crime, and due to new media, the commission and crime control are changing and becoming even more harder than ever. So actually, in past hours, some interesting things have happened in the world and in Georgia as well. Yesterday, I found out that YouTube banned all the anti-vaccination videos from its platform. So whoever wants to spread anti-vaccination campaign, they cannot use YouTube anymore. So this is very interesting fact, and it is really related to our topic today. And another fact is that because of new media and the information that we are getting every day, we don't even know what reality is anymore. And good example is our former president, Mikhail Saakashvili, who this morning announced that he returned in country, in Georgia. Actually, he is sentenced for committing several crimes. And for 8 years, he was living in Ukraine and other countries. And he holds official position in Ukraine. And he announced today that he is in a country, in Georgia, and he's sentenced for committing a crime. So usually if such kind of person enters the country who committed a crime, police will arrest him right away. So basically, he said that he is in the country. He is not arrested. So, on the other hand, our government said that he's not in the country. They denied the fact that he's in the country. So we regular citizens don't know whether this guy, our former president, is in country or not. So this is how reality and perception of reality is changing in modern day life. And this happens every day, like this kind of things where we don't know boundaries, where reality is. This kind of things happen every day in Georgia. Moreover, recently, Georgia has experienced its first so-called Facebook crime when Georgian far-right launched disinformation campaign, as a result of which one of journalists was beaten to death and approximately 50 others were injured. Facebook crimes mean that crimes or incitement to commit a crime are being documented online, and that without further moderation is disseminated to the wider public. Thus, it is logical that questions are being asked about the responsibility of new media in crime control responses. So today I will talk about disinformation, what disinformation is, and what relation it has to other concepts like fake news and misinformation. I will talk about the harm principle, which is the basis, one of the main bases for criminalization. Then I will talk about challenges to define a crime in the era of social media, because like I said, boundaries is blurred, what crime is and what crime is not. Then I will speak really briefly about the value of free speech, and then I will summarize about the cons and pros for criminalization of disinformation. So to start, like I said, about the definition of disinformation. So the EU Action Plan Against Disinformation defines this act as verifiably false and misleading information that is created, presented, and disseminated for economic gain, or to intentionally deceive the public and cause public harm. Public harm in this case includes threats to democratic processes as well as to public goods such as union, citizens, health, environment, or security. Disinformation does not include inadvertent errors, satire, or parody, or clearly identified partisan news and commentary. Often when it comes to spreading false content online, alongside with disinformation features the term misinformation and fake news. And during our conference today, these terms also were said by our participants. It shall be highlighted that even though broad definition of fake news captures disinformation, these two concepts are not synonymous. Generally, fake news can be understood as distorted signals uncorrelated with the truth. Even though spreading a fake news is a purposeful act, the creator does not directly or indirectly intend to cause harm to public. Fake news, be it a news report, personal story, or other, aims at misleading people with the wrong information, while disinformation aims to harm a person or a society. These deceptive ploys are created to push a particular political viewpoint, cause concerns or moral panic, or in some instances, make money for dubious companies or individuals. As for misinformation, it is a type of false content that is unlikely to harm anyone, and creator or spreader shares this information only for the reason to get a point across. So if someone believes that they are sharing the truth when it is in fact false, they are spreading misinformation. For example, just to give you an example to have clearer distinction between these terms, false information that claims that COVID-19 vaccines are ineffective or even dangerous for pregnant women can cause actual harm, as the refusal to vaccinate could lead to spread of the disease and even death of pregnant women. This would be disinformation. If someone thinks that they are sharing scientific article that in reality is just a post from another user from Facebook who claims that COVID-19 vaccines are dangerous for pregnant women, this would be misinformation. If someone would craft information on COVID-19 vaccines in such a manner to push a particular political viewpoint or cause concerns, this would be fake news. Now let's move on about the issue of criminalization, which is the most important part when we are talking about restricting of some kind of certain type of act. We have seen that disinformation is a type of act that is threatened to cause harm to others. Traditionally, a starting point of talk about criminalization is harm principle, which cannot be discussed without such a philosophical opinion as liberalism. One of the main principles of liberalism is the following statement of John Stuart Mill, who said that the only justificative reason because of which it is acceptable to apply force on a member of the civilized world against his or her own will is that others must be protected from harm. The harm principle expressed in this way is a negative restriction, which means that in case when there is no harm or no danger of harm, the state is not authorized to intervene in its citizens' activity. Accordingly, when talking of the harm principle, a question is naturally arising about the consequences of the act. Does it harm anybody? But what is meant by harm? A human is harmed generally when his or her one or several interests turned out to be in a worse state than they were before act was committed against him or her. Everybody has future perspectives and plans to make life better. When men are harmed, it means that their perspectives are getting worse, but it does not mean that their life always gets worse. They might reach the intended goals, but it's not a determiner. Important thing is that a man is reaching his goals with the more difficulties than in case when there is no harm at all. Following from this principle, the essence of criminalization of an act is avoiding harm. In the harm-based prohibitions, harm is a component of crime or a descriptive element of crime. For example, murder does not exist without a person's death. Just a person's death is the harm justifying criminalization of this act. But except murder, a person's life can be protected by prohibition of attempted murder, unlawful bearing of arms, violation of traffic safety rules, and etc. This means that there exist several types of harms, which on the stage of criminalization needs to be taken into consideration. And as you see from the slides, there are three types of harms that is known to us. One is immediate or direct harm, which directly does harm to a person's health or property. In such cases, wrongfulness of the act is based on the harm. For example, when A harms health of B, his act prima facie is wrongful and potentially the ground of criminalization. In other words, infringement to the health of B is wrongful as it harms him. So everything is clear when we are talking about the direct harms. Accordingly, in deciding criminalization issue, legislator must take into consideration the severity of the harm, the probability of its occurrence, and adapt them to the social value of the act to be prohibited and the degrees of intervention in humans' freedom, including, let's say, freedom of speech and other human rights. There are types of action that become harmful by tending to diminish the resources that underpin well-being, not immediately, but remotely. This is another type of harm, remote harm. For instance, selling a firearm, which is a crime, does not in itself harms anybody, right? But the action is still criminalized since it puts a person in a position where subsequently they may harm another person. This possibility is an implicit feature of many inchoate offenses, such as incitement of murder. While it may be sometimes appropriate to criminalize actions that have remote harm, very often there are difficulties about basing criminalization on remote harms. It seems unjust to impose penal censure to somebody, at least where they have little or no ability to control the potential harmful choices of other persons. And the last type of harm is secondary harm. And this type of harm shares the indirect character of remote harms. Harm can also occur when people are affected by the prospect rather than the actuality of a wrongful action. One reason why state sometimes intervenes to prevent public nuisance like graffiti, let's say, is not that the relevant action is harmful for anyone, but rather than avoiding it causes great inconvenience. There is so basically what harm principle, to summarize what I just said, what harm principle states is that state can only intervene in its citizens' actions if an act causes a harm or danger of harm to others. And what is even more important is that harm needs also to be wrongful. Not all harms are candidates for criminalization. There is a wide consensus in Georgia that crime is a wrongful and guilty act provided for by the Criminal Code of Georgia that results in punishment. Basically, this definition is the outcry of the principle of legality, which states that there is no crime without the law. But a harder question is, what shall constitute a crime? It shall be argued that what is defined as being a crime in a reflection of the values of, is a reflection and values of mainstream society, and that some acts is defined as crime because it causes a harm. To give you some examples, for example, in the US, after the Boston bombing, the citizens identified the wrong person as the bomber and incited harassment against his family, which brought them unnecessary pain as he was missing, and then eventually committed a suicide. Should this action be a crime? Should these individuals be held responsible for the harm caused to the wrongfully identified person's family? Similarly, in the case of the Chibok girls who were kidnapped in Nigeria, news reports that were posted and reposted on social media said that Chibok girls were not kidnapped and claimed the story was fake. This is thought to have negatively impacted the humanitarian effort to rescue the girls. Clearly, here as well, harm is evident, right? But should those who posted claims that this human rights crisis was fake needs to be held responsible? To take a case of Georgia, a couple of months ago, hours after bank robber took hostages and escaped with $500,000 US, someone created a Facebook profile of the alleged bank robber and was posted different types of false information about the whereabouts and the reasons for committing the crime. This also had negative effect on proper investigation. And even at the period, and even today, so to say, this person is not being arrested. He is somewhere, I don't know, some are saying that he is outside of Georgia. Some people are saying that still he is in Georgia, but the fact is one, that because of this false information, this person was not arrested. I mean, this is one of the reasons why he was not arrested. In all of these cases, we can see that the social harm that was caused, in one case, a wrongly identified suspect's family experienced harassment and eventually the person committed a suicide. In the other cases, effective investigation have been delayed. As mentioned in the beginning of my presentation, the consensus definition of crime suggests that what is defined as crime is generally agreed upon. As crimes using new media are relatively new, there might not yet be agreement about the behavior as criminal. And another definition of crime, the interactionist definition, argues that behavior becomes criminal when society construct it as criminal. With these new media examples, it may be said that it will take time for society to begin to view this behavior as criminal. In the meantime, cases like this draw attention to how social media is challenging definitions of crime and the pursuit of justice. These examples also showed us that even though it is evident that such kinds of false information causes clear harm, sometimes direct harm even, and falls under harm principle, question still remains. Shall we criminalize it or not? So we talked about criminalization. Now we need to move our focus on value of free speech, and I will be brief, like I said. Freedom of speech reinforces all other human rights, allowing society to develop and progress. The ability to express our opinion and speak freely is essential to bring about real change in society. Having this in mind, Constitutional Court of Georgia has several times reiterated that free society consists of free individuals who think freely, hold independent and different opinions, and participate in democratic processes, which entails exchange of opinions and debate. Having said this, it is also worth noting that in Georgia, periodically certain initiatives are put forward which are aimed at limiting freedom of expression, which has become a dangerous trend. For instance, in 2015, the High Council of Justice, which is the main administrative body of whole judiciary, published a statement calling on the government and other political parties, civil society, interested groups, as well as the media, while they are exercising freedom of expression, to refrain from statements that can damage the authority and the prestige of the judiciary and can cause loss of public trust towards the court. Another famous example was that there was a legislative initiative launched within the Parliament of Georgia, and according to this draft law, they wanted to restrict the actions that abuse the religious feelings of Georgian citizens. Luckily, this law did not pass, but what I'm saying is that there were trends that in recent period, there are attacks on freedom of speech in Georgia. So we should be really cautious. And like I said in the beginning of this my presentation, disinformation is a false content that is intentionally disseminated with the intent to harm. It occurs when people intentionally spread information that is false, biased, manipulative, or propaganda. Even it causes problems and even sometimes causes a harm. It was also established that as criminal law is the strictest means of social control, a negative influence of which follows a person till the end of his or her life, its usage must be minimized, or to put it another way, criminal law shall be used as a last resort. From this derives the statement that criminalization shall also be used as a last resort, and it shall be justified on every case, on every occasion. In order for this to happen, criminalization of certain acts needs to follow principles of criminalization. And like I said, starting point is harm principle, which entails that state can only intervene in its citizens' actions if an act causes a harm or danger of harm to others. Clearly, disinformation falls under the harm principle. In most cases, there is no direct harm, but at least remote harm is at hand, which means that action tends to diminish the resources that underpin well-being of certain group of people or society, not immediately, but remotely. Even more, disinformation is intended to cause harm. So it is safe to say that the action falls under the harm principle, and there is a prima facie case for its criminalization. But when prohibiting the act, while state is balancing pros and cons for criminalization. Sorry, I forgot to switch my slide, so this is it. In percentage, you will see final result. I mean, you can answer question of this presentation, whether we can criminalize it or not in numbers. So you just need to calculate and you will get final answer whether we need to criminalize it or not. Based on my formula, I may be mistaken. But when prohibiting the act, while state is balancing pros and cons for criminalization, other side factors need also be taken into calculation. Namely, attention shall be paid not only to the wrongful harm of the action, but also to the level of restriction of human rights, and in our case, freedom of speech. If freedom of speech had the value that I said that it has in this presentation, then we can simply recall one of the main propositions of criminalization. The more valuable and important is the act, or the more it restricts human freedom, the more unjustified is the prohibition of the act. This means that even though action falls under the harm principle and is a really good candidate for regulation, we need to think again while we decide to criminalize this action. Freedom of speech is of such a big value that its restriction with the strictest means of social control needs to be restrained. The need for restraint in criminalizing disinformation derives from the fact that freedom, democracy, and every other rights derive from freedom of speech, actually. And since disinformation causes only remote harm, this means that the actual severity of the harm caused by disinformation remains in doubt. Even if some harm arises out of disinformation, punishing or imprisoning the suspects is a disproportionate response. Yet, the problem is not just one of proportionality. It also concerns the state's power to make itself the sole moderator of the content or the arbiter of what is true or false. Moreover, before an act is criminalized, the cost and means of enforcement needs to be also taken into account. If criminal law cannot be enforced or its enforcement is inefficient, then this will cause inflation of criminal law itself and will be basis of so-called over-criminalization. The latter problem is already exists in Georgia. So shall we regulate it or not is obviously up to the state, but my opinion is that this action shall not be criminalized, and also, but it shall definitely be regulated. So there are other means of regulation, like civil law regulation, administrative restriction, or creation of social media council, like Nina and Sergey mentioned about this institution and about pros of this, the existence of this institution. And I stand alongside with them. And also creation of social media council will mean that the content that is disseminated by social media will be moderated, not by the state, but by the independent body who will compose with the members of civil society and other professionals, and they will decide on a case-to-case basis whether this or that particular action needs to be regulated or restricted from social media. So basically, this is it. This is what I wanted to say about criminalization of disinformation. I am, if you have questions, I am free, and I will try to gladly answer them. Thank you.